been listening to the closing arguments as presented by the prosecution in the Derek Chauvin murder trial. Let's get straight to CBS News legal contributor and former federal prosecutor Keir Dougall. He's joining us now to break this all down. Keir, the prosecution started their closing argument by talking about George Floyd and his family. They ended those closing arguments by talking about the witnesses who were with George Floyd during his last moments. The prosecutor is saying that they were chosen by fate, that in fact George Floyd was not alone. He was surrounded by people of his community who were essentially pleading and begging for his life. How do you see, and how much weight do you think that this humanization of George Floyd in a case like this, what kind of weight does that have with the jury?
Well, I think it's very important because, of course, George Floyd was a person. He was a human being. He wasn't a superhuman, as the prosecutor was very careful to say. But it goes directly to Mr. Chauvin's state of mind. It goes directly to the fact of his actions and what a reasonable person would have been thinking in those circumstances. So I think it was very powerful, and I think it was very effective.
The prosecution also took some time to talk about just how George Floyd died. I want to play a little of that sound for you, and then we'll talk afterwards.
On May 25, 2020, George Floyd died. Face down on the pavement, right on 38th in Chicago, in Minneapolis. Nine minutes and 29 seconds. 9 minutes and 29 seconds. During this time, George Floyd struggled, desperate to breathe, to make enough room in his chest to breathe.
I wasn't sure whether or not, I don't even know if it's an option in sort of closing arguments, whether or not they were going to show that video, but he sort of almost showed the video in words. What was the strategy here?
Well, this ties into the causation argument. After watching that presentation, which was a good presentation by the prosecutor, a strong presentation, you're left to wonder, well, what can the defense say? And so we're going to hear a lot, I expect, about three things. One is causation. The next is justification, and was the use of force reasonable? And then I think we'll hear this over and over again, the high standard of proof beyond a reasonable doubt that the prosecutors have to meet. So that sound that you just played, Anne-Marie, is about causation. It's about George Floyd being unable to breathe.
Keir, the other point that I thought was interesting, and Anne-Marie and I were talking about it, conversing as we were listening to the prosecutor there, was something that I may have missed it throughout the weeks that we've been watching this, but where he broke down succinctly for the jury the difference between risk and threat, and what that means to the use of force, what police officers are, when police officers are authorized to use that force and when they are not. And he described the risk inherent to policing, which is that everybody who's not a cop is potentially a risk to a police officer. But then he showed that moment in the video where Derek Chauvin is speaking to one of the bystanders, to one of the witnesses, where he said, George Floyd was a pretty big guy and he may have been on something. And the prosecutor made clear to point out to the jury that just because somebody is a big guy does not mean that they are a threat to a police officer. They may be a risk, but they're not a threat. Just because somebody is on drugs or allegedly on drugs could mean potentially they are a risk, but they are not a threat. And if they're not a threat, they're not authorized to use that force. How much weight will the jury take that into account? That sort of, it was literally just about 2 or 3 minutes, but it felt to me like it carried a lot of weight.
Yeah, and Vlad, this calls back to the testimony of the defense expert on use of force. And we talked about this the other day, Vlad, about how that expert had said the cops don't have to fight fair. And I think that as I said before, I think that is an improper way to describe what a police officer should be assessing at the moment. But you also heard in the closing, in the argument just now, the prosecutor calling on the jury to reject that testimony, that the jurors do not have to accept that testimony. And it's important that the prosecutors win this point. You'll recall that the defense expert, the gist of his testimony was that Mr. Chauvin's use of force under the circumstances, he believed was reasonable, even though it didn't fall within the Minneapolis Police Department's rules and regulations. This is where the battleground is going to be fought in the closing argument that I expect you're going to hear from the defense attorneys, and this is where the decisions are going to center around, I believe, in the jury room. The jurors here are the deciders. They are going to decide whose testimony to credit, whose testimony to reject. But I thought that it was one of these areas where the prosecutors are not saying it directly, but this is an area they have to win. In other words, if they don't win the request that the jury reject that testimony, they're going to have trouble with the outcome.
And it seemed like they were also sort of anticipating that there may be jurors who find it difficult to convict a police officer. We know that the defense, spent some time describing the chaos of the scene, and it seemed like the prosecutor said outright, policing is an honorable profession. It seemed like they were sort of trying to get ahead of any doubts that a juror might have, that they wouldn't have the ability to sort of judge what police officers do in these extreme circumstances. And you heard the use of the phrase, a reasonable officer, a normal person, kind of back and forth. And I wondered if part of that strategy was to kind of have the jurors essentially say, well, what would you do? You're a normal person. What would a normal person do in those circumstances?
Anne-Marie, you would be a good prosecutor, because that's exactly the strategy, is to anticipate the defenses and try to pull the punches and give the jurors comfort. I like to think about proof beyond a reasonable doubt effectively as asking jurors to be comfortable to vote for guilt, to vote to convict, and then to be able to go home and sleep well at night. You heard discussion about a reasonable doubt is one that's based on reason and common sense and not based on nonsense. So that's correct. The point is the prosecutors are trying to pull those punches, trying to give and arm the jurors in the deliberation room with the evidence so that they can find the defendant guilty.
Yeah, and to that point that Anne-Marie made too, I thought it was sort of powerful for the prosecutors to also point to another term that we've heard used not just in this trial, but oftentimes when police officers are arresting people. We heard it in the Eric Garner during the Eric Garner trial. That in this case, because George Floyd was a big guy, that he might be potentially on drugs, allegedly, that he may have had superhuman strength, that people who are under the influence, people who are large, can have superhuman strength. And I just thought it was sort of an interesting and frankly powerful moment for the prosecutor to explain that does not exist in the real world. That's not a real life term, and the jury shouldn't consider that to be so, because everybody here is a human being, and George Floyd was a human being, and no one has superhuman strength. That doesn't exist in the real world. And to the point Anne-Marie was making about police officers, he made it clear. He said this is not an anti-police prosecution. This is a pro-police prosecution because of the actions of Derek Chauvin.
Yeah, Vlad, it verges on, I mean, if you react to this not as a lawyer, but as a normal person, and I'm going to pretend that I'm a normal person for half a second here, it verges on the offensive to suggest that George Floyd was somehow other than human, that he's in some category of superhumanity, and not like all the rest of us, not just a human being. And I thought, for me, one of the most moving moments of the summation was when Mr. Schleicher said that it happened right there on Chicago and 38th, a real place to a real person, and he ticked down what I expect to be the causation arguments and just ticked them off as nonsense. Nonsense that the car did it. Nonsense that George Floyd was a superhuman. Just went down and asked the jurors to gather the testimony, believe their own eyes, and find the defendant guilty. But, as a lawyer, now stepping back as a lawyer, I expect that Mr. Chauvin's counsel's job is to effectively make every argument that he's lawfully permitted to make. And, those are going to include proof beyond a reasonable doubt, questioning causation, and arguing based upon this testimony from the defense police force expert that Mr. Chauvin was justified. I expect we're going to hear a lengthy dissertation on that from the defense lawyer.
And the prosecution also spent a lot of time breaking down the video of George Floyd, of them attempting to put him in the back of the police cruiser. And I thought to myself, yeah, they really do need to take time here, because if I was just somebody walking down the street and I kept on walking, I didn't stick around for the whole incident, and I saw this occurring, I would look over and go, that guy's resisting whatever the police are trying to do to him. And instead, the prosecutor sort of retold it in a way that, once again, injected humanness into George Floyd, that he was terrified. It's really tiny back there. What would you do if you were somebody trying to stuff you into a sort of a tiny little box? You would try not to go in there and explain why you don't want to go in there. How valuable do you think that was, that the prosecution sort of broke down that particular part of the interaction that George Floyd had with police?
Anne Marie, I had some of the same reaction that you did to that narrative, to that explanation of sort of the movie version, the chronological version of events, that Mr. Floyd was trying to comply, and where he could, he did at multiple times. And I thought explaining the difficulty of having Mr. Floyd get into that car as not a matter of resistance, but one of inability to comply, I thought that was very effective and very moving. But the key, I think, part for the prosecutors are, once they give up and he's on the ground, handcuffed and prone, what happened before that, it doesn't matter anymore. You judge the use of force. On the prosecutor's theory, you judge the use of force at the moment that you're applying it. And I thought that, after that humanizing explanation of what occurred with respect to getting him in the car, the transition then to say, okay, but let's look at the use of force when he's on the ground, and it was not reasonable. Pulling together multiple witnesses throughout the Minneapolis police organization to say this is not a policy, it is not justified. I thought that was very powerful. It was a very powerful segue and a way to arm the jurors to feel comfortable to vote to convict Mr. Chauvin.
But let me play devil's advocate, Emery and Keir. And I actually, when I was watching that moment, I wondered if it was a misstep by the prosecution, and here's why. I know a lot of police officers, both that are cops now and retired, and they would say, and as they have said throughout this trial, almost all of them believe that Derek Chauvin acted inappropriately. But one thing that they will say is, look, there have been many, many times when you are arresting somebody and you put them into the back of a car. All these vehicles are essentially the same. I mean, there may be some variations in make and model, but the thousands and thousands and thousands of arrests that happen on a regular basis where people get into the back seat, big, tall, large, skinny, whatever you want, and nothing happens. So the notion that George Floyd would say, I don't want to get into the back of the car because I'm claustrophobic, somebody could say, a reasonable police officer would say, I've heard this before for people who don't want to go to jail, that they don't want to get into the back seat of a car because they're claustrophobic, because it's too tight. On the flip side, I will say that what the prosecutor did in showing out the entirety of the video is when they removed him from the back seat and Mr. Floyd said, thank you, I thought that was powerful because it basically said, I'm complying and I'm glad that you're helping me also comply. Thank you very much. That was before Derek Chauvin put his knee on his neck.
But the thing about it, Vlad, is that it's not a jury of police officers, right? It's a jury of regular people. And, they're going to think if you've ever seen the back of a police cruiser, and I have, but for, legitimate reasons, it is pretty tight back there. I'm a pretty short person, and I feel like there's not a lot of space.
Yeah,
so
I was pretty surprised. I've never seen the inside of a back of a police car, but I was pretty surprised when they showed.
There's not much room.
Yeah, there's not a lot of room there.
Yeah, Vlad, those are good points, and I think that's why you come back to this idea of 9 minutes and 29 seconds. Okay, so did the prosecutors have to give that explanation about whether or not he was resisting or whether or not he was just unable to comply? They didn't. I don't think they had to. It wasn't an essential piece of the case, but even if you take the devil's advocate view, Vlad, and it's a reasonable one, that he was resisting at a certain point, the segue that leads to thank you, and now he's on the ground and he's no longer resisting. He is no longer a threat, and you look at the entirety of that length of time. That's when, and the prosecutor was explicit about this. This is when we start measuring what the use of force was. It's at that moment when he's on the ground. That's where I think Mr. Chauvin and his defense lawyers have a lot of work to do, and I think you're going to hear a lot about reasonable doubt, trying to get one juror to think in terms of prior resistance to arrest, and I'm sure that Mr. Chauvin's lawyer will describe a threat, even though Mr. Floyd was on the ground.
So let's talk about that. What do we expect to hear from the defense? What areas do you think are just weak enough that they could, work and, change the mind, or not change the mind, or help or influence at least one juror? That's what I meant to say.
Yeah, absolutely. Sure. So, they've put on a case with their own experts, and you've already heard the prosecutors calling on the jury to reject and not accept the expert testimony. And that's implicitly signaling a potential weakness in the case, because if the jurors accept the defense expert testimony, the prosecutors will have problems. So the judge gave the instruction in the first area that I think we should hear a lot about, in causation, and said that Mr. Chauvin's actions have to be the substantial cause in a natural chain of events. I would be surprised if we didn't hear the defense argument that he wasn't the substantial cause. We're going to hear, I expect, all the different things that the prosecutor just called nonsense, the heart condition, the drugs, the carbon monoxide, that list of things. I expect we're going to hear those things either from the defense side as, well, those are the substantial things that led to Mr. Floyd's death, or potentially those are going to be argued as superseding events under the judge's instruction. And in rebuttal, I think what you're likely to hear is when the prosecutors have their final word, they get the final word because they've got the burden, the ultimate burden of proof. You're going to hear, we already heard this a little bit, what a coincidence it must have been that Mr. Floyd's heart chose, if you believe that theory, that his heart chose that moment to give out and cause his death. What a coincidence that even though his blood levels, fentanyl levels were below what an overdose would look like. What a coincidence that that is what caused his death, and it wasn't the acts of Mr. Chauvin. That's how I expect that argument, that set of thread of the argument to play out through the defense closing and the prosecutor's rebuttal. The other argument is going to be on justification of use of force, which we've just talked about. That the defense expert, Mr. Broad, is going to say a reasonable officer would have perceived a threat. That's the argument that's going to come from Mr. Chauvin, I believe, or that there is a reasonable doubt that Mr. Chauvin could have believed that he needed to use that force, and that there's a reasonable doubt about whether or not he was justified. So I expect you're going to hear those two threads throughout the defense closing.
And yet, I guess, Keir, when the prosecution showed video with Mr. Chauvin's knee on George Floyd's neck and him casually picking the stone out of the tire of the police vehicle and sort of saying, to Mr. Floyd's cries of help, for help, I wonder, again, going back to the discussion around threat and risk, what kind of a threat Mr. Floyd would pose if you're so nonchalant about what is happening, what he's doing. How hard is it for the defense to make that case if the behavior as seen on the video is so different? If the behavior from the bystanders, which is, look, these people, really pose a threat to me, that's why I've got to, keep this posture. When you're looking at video of a child with a sweatshirt that says love on it, who's also pleading in much the same way that the adults are pleading. I'm sure Mr. Nelson is going to show some video, I'm guessing, of when the witnesses were a little bit more belligerent. But again, you're talking about like as if we are pulling ourselves away from our traditional roles as journalists and as a lawyer, and sort of saying, as a common sense person, you look and say, I don't know if this poses a threat. I don't know if George Floyd is a threat. If you're able to sort of casually pick a stone out of a tire.